Great, thanks, Matt. As Matt said, my name is Brittany Smith. I'm one of the attorneys here, and I really work in our long-term care planning department and our state administration department, where individuals are really concerned about protecting assets and shielding assets. If you ever would need in-home caregivers, or you'd have to go to a skilled nursing facility. And I work a lot with Tammy Zilske as well. She's going to be talking here in a minute. And we also help individuals navigate the Medicaid process. That can really be a challenging process sometimes. So we really focus on that, but we also do a lot of trust work. So today we're going to talk about the Irrevocable Asset Protection Trust, what it is, why you might consider signing one, and really what its purpose is. So before we would have you set up any sort of trust or do any sort of estate plan, we always start with what your goals are. You know, why are you here? Is your main concern protecting assets if you would need care, applying for Medicaid benefits? Or you may be just concerned about your distribution after you pass away. You want to make sure, you know, assets get distributed how you would want. Maybe it's a second marriage situation, or there's creditor concerns with your kids. So we always want to focus the trust on what your main goal is and really customize it to meet, you know, whatever the purpose is in establishing the trust. All right, so, you know, today we're going to talk about the Irrevocable Asset Protection Trust. So really, what's the purpose of that type of trust? So we really look at that type of trust if you're looking to protect property either for your spouse, you know, if one of you gets sick and the other has to go in the nursing home, you want to make sure everything's protected for your spouse. Or, you know, you have worked hard all your life, you want to make sure all your assets are protected for your children, grandchildren, nieces and nephews, whoever you would want to receive your property. This is a good trust to make sure something is left to them and protected. And then also it's to really protect your house and any of your other assets from having to be paid back to the state of Pennsylvania after you were to pass away. So we're going to talk a little bit more about the estate recovery lien, but by putting it in a trust, it really helps protect your home. That's really where we see it the most, from having to be sold when you pass away and just that money being turned over to the state of Pennsylvania. So those are all really good reasons to look at the irrevocable trust. Now, the word trust tends to scare people a little bit. They tend to think it's this big, complicated device that has to be managed by a bank. It's really just for rich people. Do I really even need one? And it's not for rich people. We try to make our trust as user-friendly as possible and still give you as much power and control as we can while still retaining that protection. But you can really protect any assets that you have. If you have a bank account with maybe $50,000 in it and that's what you want to protect, or your house, you know, those are all good things that we can look at putting in a trust. You don't have to be a millionaire. You don't have to have several $1 million to have a trust. It's really for anybody if your main concern is protecting assets if you were to go in the nursing home. Now, I keep referencing the irrevocable trust, and this is a key distinction for Medicaid and nursing home planning. So a lot of people might have a trust that's known as a revocable trust, which means you can amend it at any time, you can get all the money out at any time, you can revoke it. And because you have that much power and control over the assets, if you were to go in the nursing home and it was the revocable trust, they would say, great, you know, terminate the trust, get everything out of there and use it to pay for your care. So it doesn't have the same protection as the irrevocable trust. And basically all irrevocable means is that once we were to transfer your property or put it in the name of the trust, you can't just get it back out. There are certain limitations, but again, we're going to go through how it works. And we do try to give you as much control over that property as possible, just as if we kept it in your name alone. Okay, but the irrevocable part is just really what helps protect it from creditors, and one of those creditors would be the nursing home. All right, and then we did touch on this a little bit. So the estate recovery lien, what happens is if you were to go in the nursing home and you would have a house that was just in your name alone, if you apply for Medicaid benefits, you're essentially asking the state to pay for your nursing home care while you're in the nursing home. Now, the good thing about Medicaid is they won't make you sell your primary residence. You can keep it, they exclude it as an asset, but what they do is they try to recover it then whenever you pass away. So if you would still have your home and you've applied for Medicaid, they've paid, say, $200,000 for your care during life, they're going to try to recoup some of those funds. So what will happen is whenever you pass away, they'll make your executor sell your house, and then they'll say, great, give us all of the funds to help satisfy this lien because we paid so much for their care during life. So the good thing about a trust is it's not your asset anymore. You've transferred it out of your name, and it helps shield it from ever having to be sold when you pass away and just the money being turned over to the state to repay for the Medicaid. So that's one of the primary reasons that we see it is people don't want to have to just pay all those funds back to the state. They want something to be left for their children. And then even during life, once you transfer assets to the trust, Medicaid does have the 5-year look back, so we're going to go through some examples of how that works. But once you transfer it to a trust, if you make it through that 5 years, all of those assets are protected from your nursing home care. So you don't have to dip into the trust to pay privately. All of that's not considered your asset anymore and is protected. And then, even if you have any beneficiaries, say you have a son who's not good with managing money, or you have a daughter who might be looking at a divorce, and you might have a concern with them getting an inheritance outright whenever you pass away. One option is you can set up a trust for them, and it really just kind of stays in trust. That way it's always considered their separate asset, and creditors or ex-spouses can't get access to it. And you can really control how that's distributed to them. If you want them to get $5,000 a year, $2,000 a month, whatever that is, you can really set that up and manage that even if you were to be passed away. And then another benefit, I don't recommend setting up a trust just to avoid probate, but a lot of you have probably heard of this term where you have to have someone appointed as your executor once you pass away. They have to go to the courthouse and get sworn in. And really what that does is that makes your will public record. So the good thing about a trust is it avoids that entire process. Because again, anything in the trust is not in your name anymore. So you don't have to file anything at the courthouse. Nobody has to formally get appointed. You would actually appoint who would manage that if something happens to you right in the trust document itself. Okay, so the court doesn't have to get involved at all in that process. And then the third one, the federal estate tax, we don't really have to worry about that too much anymore. So under the new tax laws, you don't have to worry about paying the 40% estate tax unless you have more than $11.58 million. So if you're in that range, you and your spouse together have more than $22 million, then you might want to look at setting up a trust to kind of shield some of those assets and get them out of your estate to avoid that higher tax. But most people, right now with the current tax laws, they don't have to worry about that tax anymore. And then we did talk about just managing it after you pass away. If you're worried about, your children receiving it outright, you can set up whatever terms you would want for them to receive that inheritance. Now, one of the questions I get a lot is, well, I know I need to get all of this out of my name, but I don't feel comfortable with a trust. Can't I just give all this money outright to my children? Can't I just put my child's name on my property? Well, that is an option. You can do that, but we don't recommend it. It's not the wisest option. And the reason we don't recommend it is say you transfer these assets to your child outright, now it's their funds, and they get a divorce. If you put your house in your child's name and they get a divorce, that's going to become part of their divorce action. So you might lose your house to your ex-in-law. Nobody wants that. Or if they get in a car accident and they have creditors looking to attach to some of their property, you could potentially lose your house to their creditor issues. And, the same if they were to pass away. Say you want your house to go equally to all your children or to somebody else, but it's in your son's name and he passes away and he leaves it to his neighbor. You might not even know his neighbor, but it's really going to be controlled by whatever his will and his estate plan would say at that point. So the good thing about a trust is it helps get it out of your name for Medicaid and for nursing home, but you still have control over it and it's not subject to any of those creditor issues. So it's not going to be subject to your child's divorce action. If they were to pass away, you set up where those assets go if they pass away. So it really helps make sure that they're going to be available for you if you would ever need them in the future, instead of just giving them outright. All right, and then we just have a fun little cartoon here for you. So it just says, what if we have trust issues? I hope you mean our estate plan. We just thought that was cute and wanted to include that today. All right, so what exactly is a trust? How does it work? Well, a trust is really just a legal document. It's just a piece of paper that you would come in and sign. You establish the terms of how the money is managed that you put in there, who's in control of everything. So it really doesn't have any protection until you would actually transfer assets to the trust. And by transferring assets, it's really just titling accounts, putting them in the name of the trust, doing a deed for your property to put it in the name of the trust. So you don't have to close anything out, and we help you through that entire process, but it's really just retitling everything so that that document is the controlling document. Now, you really need to be thinking about several key individuals, and we're going to go through what each of these individuals do, but you need to be thinking about the trustee, someone to access the funds, that's the trust protector. Who would you want to receive the assets in the trust when you pass away? That's the beneficiaries. And then we also have to be concerned about the tax implications. So before we set up a special type of trust, we need to look at all the tax implications. All right, so the first role is the donor. The donor is really you, the individual that's transferring the assets to the trust. So if you have real estate or an investment account, you're just going to be the owner and transfer it in the name of the trust. And it's really your decision. So what we like to do is we kind of like to collect all of your asset information, your real estate information, and then we would make recommendations based on what we would feel would be good assets to transfer. But it's really ultimately your decision and your comfort level. So if you want to protect more or if you want to protect less, it's always your decision as the donor of the trust. And then our trusts actually allow you to also be the trustee of the trust. So the trustee is really the driver, the one that's really managing everything that's owned by the trust. So if it's real estate, it would be your decision when to sell the real estate, who to sell it to. If it's an investment account, you can decide where to invest it, make all the investment decisions regarding that stock. So the good thing about our trust is even though you're transferring it to the trust and it's getting out of your name, you can still pretty much manage the account or the real estate the same as if it were just still in your name alone. Okay, so you don't have to get anyone's permission to sell your property, purchase another property. All of that is still your decision. Okay, and we talked about the investment decision. So if you have a special advisor that you work with, you can keep all the accounts with them, just retitle everything. So you don't have to cash all the assets out. Now, the only power that we can't give you as a trustee or as the donor is the power to make withdrawals from the trust. So like we talked about earlier, if you had the power to write a check out of the trust or get all the assets out of the trust, the nursing home would say, great, get everything out of there and use it for your care. So what we like to do is we understand that you might put something in the trust that you might down the road need access to if a roof leaks or you need a new car. So we put in a back door where you don't have access to that, but you can appoint a trusted individual that would be able to get into the trust and get that money out for you if you were to need it. Okay, so that's really the trust protector. And a lot of times, we recommend your children or somebody in the family that you would trust in this role. And we always recommend at least 2 individuals. That way there's kind of a checks and balances. So one can't just write a check without you knowing it. There's always, a balance system in place. And we also use this for gifting. So a lot of people like to make gifts during their life. That way they can see their children or grandchildren enjoy the money. So, with the 5-year look back, each time you make a gift, Medicaid's going to be keeping track of that. And if you were to go in the nursing home before 5 years, they're going to penalize you for those transfers. But the good thing about a trust is once you put the assets into the trust, they're not tracking really what you're doing with that money. So for purposes of your 5-year look back for gifting for Medicaid, it starts the day that you transfer the assets to the trust. So say 2020, you transfer the assets, but you tell your trust protector, I want to give $5,000 to my granddaughter from the trust. They can do that at any time, and you're not going to have an additional penalty for Medicaid. So that's a lot of times what we use for gifting. That way it doesn't penalize you in the future. And then, some people are concerned, well, what if I go to my trust protector and they refuse to get the money out for me, or they do something that I don't authorize with the trust? We give you the power to add and remove them at any point. So if you were to find out that they took out money without you knowing, or you go to them and they refuse to give you the money that you want, you would just come in, sign something saying that you remove them as your trust protector, and you can appoint somebody else that would do that for you. So you can always threaten them with firing them if they don't do a good job for you. And then the trust, really, most of our trusts we set up to terminate whenever you pass away or whenever you and your spouse pass away. Because a lot of people do feel comfortable with their beneficiaries getting the money outright, and they don't want it to stay in trust, down the line for their beneficiaries. So most of them do terminate, and whatever is in there goes equally to whoever you have named or whatever distribution scheme you would want to include. But there is the option, like we talked about earlier, that if you do have beneficiaries where you are concerned about creditor issues, divorce, them receiving a lump sum of money, you can actually set it up where that trust will continue, and you can appoint the trustee, whoever you would want to manage the funds for your child or your beneficiary, and you can really set the terms of what you would feel comfortable with. And we did talk about, you really are the one that makes the decision of what goes into the trust. So sometimes we'll recommend, you have this annuity or this investment account. This might be a good asset to protect, but you might not feel comfortable with that because you really know what your expenses are, what big expenditures you might have coming up. So we always make recommendations, but it is always your decision what you can put into the trust. Because the trust really is just an empty document until you would actually transfer ownership of assets to the trust. So what can you transfer to a trust? So you can really transfer most things to a trust to help protect them. So the biggest thing that we see a lot is real estate, your primary residence, because a lot of times that's the biggest asset that you're worried about protecting. But you can also do annuities, bank accounts. Life insurance is a good asset because that's usually something that just sits and accumulates. You're not really using that to live off of. Investment accounts that are accumulating, savings bonds are a good asset. Now, the only limitation is we cannot transfer an IRA, 401k, or any sort of tax-deferred retirement account. And that's just because of the vehicle that it's established in. So the way an IRA works is it's tax deferred until you would receive a distribution from the account. And because of that, you can't transfer ownership of that during your lifetime. So if we were to transfer that type of account to a trust, you would lose that tax deferred status and all of that income tax would be due. So we always look at doing an alternative. So if you have an IRA and maybe an investment account, we'll leave the IRA in your name and look at protecting whatever else we can at that point. And then also vehicles in Pennsylvania, anything that has a title, so a mobile home, vehicle, anything like that, we cannot transfer to a trust. They won't allow that to be owned by a trust. So again, you can keep those in your name alone as well. So again, we just touch on the advantages. Why would you want to transfer any of this to a trust? So the biggest protection is really from the nursing home. So again, once you get those assets out of your name, if you make it through the 5-year look back, you don't have to worry about using the trust. It just sits there. Even if you have $300,000 in a trust, you can qualify for Medicaid a lot more quickly than if that asset was in your name alone. And then also, they won't come back after any of the assets in the trust whenever you pass away. Even if you're in the nursing home and Medicaid's paying for 5 years, they can't touch anything in the trust. Now, the only disadvantage is that you don't have the direct access to the money, but again, you do have that back door. So even though you can't be the one writing out the check, you can always go to that trusted individual if you were to need some money out in the future. But we do always recommend just kind of setting aside money that might be accumulating that you might not need for daily access. So things like bank accounts that you're using to pay bills, a lot of those we'll just keep in your name alone. But anything larger than that that you want to make sure is protected, those are really good assets to think about a trust for. And then we do always want to look at the taxes before we would set anything up in a trust. And there's really kind of two different options of how a trust is taxed in Pennsylvania. Now, most of ours are going to be this grantor trust. And all that means is that you're the one that's still going to be responsible for paying the income tax on any of the assets we put in the trust. So for example, say we transfer an investment account in the name of the trust and it generates, $5,000 in interest. So that interest is still going to be reported on your personal income tax return, just like you do now. So everything's going to operate under your Social Security number. You don't have to file anything separate with the state, don't have to get a tax ID number. It really just makes it the most user-friendly option because it's taxed as if you still owned it outright. Okay, so most of our trusts are going to be set up that way. And then the good thing with setting up this way is for real estate, once your beneficiaries do receive that real estate from the trust, they get what's known as a step up in basis. So if you originally purchased your property for $50,000, but it's valued at $100,000 whenever you pass away, your beneficiary's basis, whenever they go to sell it, is going to be $100,000. It'll be whatever it's valued at on the date that you pass away. And why that's important is because capital gains tax can be anywhere, upwards of 15%. So if they sell it for, say, $150,000, it saves them a lot in that capital gains tax. So they do still get that step up in basis. All right, and then because of that, it is still subject to Pennsylvania inheritance tax. So a lot of people aren't familiar with this tax, but Pennsylvania is one of a few states that still has an inheritance tax whenever you pass away. And we'll go over the rates here in a minute. But basically what that tax does is it's a one-time tax on your assets whenever you pass away. And the rate is based on whoever is receiving those assets. So if you leave everything to your kids, they have to pay a one-time 4.5% inheritance tax. So the trust doesn't avoid that. There's not many ways to avoid it in Pennsylvania, but it does help preserve that step up in basis for what might be a higher tax. So it's kind of the lesser of the two evils. All right, but then there is the option of setting it up another way, which is known as a non-grantor trust. So this is really where the trust becomes its own entity, kind of like a corporation or a business, where you would have to file its own tax return for it. You'd have to get a separate tax ID number. So we don't do this a lot because of the extra accountant's fees and the extra overhead in managing it. But one of the reasons we might want to consider this is if you're leaving things to beneficiaries who might be in a higher inheritance tax bracket. Say you don't have children and you want to leave it to your nieces and nephews. They're going to have to pay a 15% inheritance tax, or your family friend or neighbor. So that's all, really the time that we would look at the non-grantor trust. Other than that, we try to make it user-friendly. That way you can still pay the income tax and get all the other benefits from the grantor trust. All right, so here's the inheritance tax rates based on the beneficiary. So the good thing is if you leave everything to your spouse, it's 0%. So your spouse doesn't have to worry about paying the inheritance tax. But if you leave anything to your direct descendants, children, grandchildren, great-grandchildren, it's going to be 4.5% of whatever the assets are valued at on the date that you pass away. Okay, and again, it's just a one-time lump sum tax. If you leave it to siblings, it's 12%, and then anybody else, it's 15%. So that's why we try to avoid it if you're looking at nieces and nephews or anybody other than that in the highest bracket. Another thing to keep in mind is there are certain assets that are exempt from Pennsylvania inheritance tax. The one is life insurance. So life insurance is also a good vehicle that if you have beneficiaries in the highest tax bracket, you might want to think about leaving them life insurance, which goes inheritance tax free, and maybe leaving your other descendants that are in a lower bracket, your bank accounts and everything else that would have to pay that tax. So that's something to kind of keep in the back of your mind. And then if we look at transferring real estate to a trust, we always have to keep in mind the Pennsylvania realty transfer tax. So again, this is a one-time tax at the time you would sign the deed. Now for most transfers, it's going to be excluded, especially if you're, putting the asset in a trust for your children, your grandchildren, your spouse. You don't have to worry about this tax. But where we would have to worry about it is if you want the real estate to go, again, to a niece or a nephew or somebody who's kind of down the line. And then also, this is kind of where Pennsylvania hasn't caught up with the times yet, but they will exclude stepchildren. So if you want your real estate to go to a stepchild, you don't have to worry about this tax. But if it's going to go to a step grandchild, they don't take it down to the next generation, you would have to look at paying this tax. So that's where we run into it the most, is if you want it to go to your step kids, but then if they're passed, maybe go to their kids, we can't have it go to the step grandchildren without triggering that 2% tax. We're hoping they change it, but for right now, they don't take it down to the next generation. All right, and then we did touch a little bit on the federal estate tax, but like I said, most people don't have to worry about this anymore. I wish I did, but the current limit is for a single individual, you have to pass away with more than 11.58 million. And if you're a married individual, you and your spouse have to have more than $22 million before you'd be looking at this tax. So again, if you are in that bracket, there are ways to help shield some of those assets, because it's going to be a 40% tax if you're worried about that. And then I always like to touch on the federal gift tax. So we have to keep in mind, this is different from Medicaid rules. This is just an IRS rule. But each year the IRS says that you can transfer or gift $15,000 per person per year, and you don't have to file anything, you don't have to report it to them, they don't really care about it at that point. But where people get confused is they say, oh, well, I can transfer $15,000, I'm going to do that, and then they go and apply for Medicaid. Well, Medicaid isn't as generous as the IRS. So for Medicaid purposes, you can only transfer $500 cumulative a month without having that penalty for that transfer. So always keep in mind, this is just an IRS rule for their reporting requirements. It's not a Medicaid rule. All right, and then we did already talk about the income taxes. So the grantor trust is going to be at your tax bracket because it's going to be reported under your personal tax return and your social security number. But if we would look at the non-grantor trust, trusts actually reach a higher income tax bracket a lot quicker than individuals. So that's always something we'd have to keep in mind too before setting up that trust. How much interest will things be earning and what's going to be the tax bracket? All right, so how do you administer, what are the concerns of administering both whenever you pass away? So a will, it is simpler, but it doesn't have the nursing home protection that a trust does. And both are going to be subject to Pennsylvania inheritance tax. So like I said, there's not many ways to avoid that in Pennsylvania. With wills, you will have to go through the probate process. So it would have to be on file at the courthouse, someone would have to be appointed, and they would have to go through that entire process where there might be some additional fees for that. Whereas trusts, it avoids the probate process because again, everything's owned by the trust and you list who's going to manage that whenever you pass away. So it avoids that. Both are going to have attorney's fees to help you administer it. Your beneficiaries, they're going to need some help in the process, so there are attorney's fees. Under the will, whoever you name as your executor, they are entitled to a fee for their service as well. This is clearly set by law, and it's kind of a schedule that they have to follow. So it starts at 5% and kind of goes from there. And then trust, this isn't really as clearly defined. It just has to be reasonable. So if somebody acts on your behalf, they can charge the same as what a bank in the area might charge. So if it's $500 a year or whatever the percent is, they can really do that as long as it's reasonable. But they can't say, oh, I did something for an hour, I want $10,000. That can be challenged because it's not a reasonable fee at that point. And then both documents, beneficiaries can contest what you outline. So if you leave someone $1, I don't recommend it because they will probably contest that. It's better just to leave them out at that point. You can consider putting in what's called an in terrorem clause, which basically just says, if you fight anything or contest anything that I leave you and you lose your entire distribution, your rights to your inheritance at that point. Now, these are really hard to win, these cases, and a lot of times judges won't uphold them because if the beneficiary has any reasonable cause to contest, they will allow it to go through. So I don't really recommend using them, but they are an option. All right, and now a trust, even though it does avoid the probate process, there is still a process that you have to administer it once you pass away. It's not on file at the courthouse, but it is sort of similar to probate. So you still do have to pay inheritance tax after you pass away, even if it's under a trust versus a will. The beneficiaries do have to receive notice that they are a beneficiary of the trust once you pass away. And that's really so that they can examine the trust, receive a copy of the document, and if they do have any challenges, they can bring them forth at that time. You have to advertise the trust in the newspaper. That's to put any creditors on notice. You guys probably see those little blurbs in the paper each week. Basically, they have a year to let your beneficiaries know if they have an outstanding bill or they need any money. Otherwise, it kind of clears out all of those creditor issues. And then the final income tax returns, they will have to file all of those. So even though it avoids probate, you still do have to do some administration on the back end. All right, so I'm going to turn it over to Tammy, and she's going to walk us through the Medicaid and how the trust works with that.
All right, hi everybody. Brittany just went over the details of a trust, and we're going to talk about, well, what happens if you set up a trust and now you need nursing home care? So one of the questions we always get is, if I do set up a trust and I don't have money and I'm trying to qualify for Medicaid, will it limit where I receive services? And the answer to that is it does depend on where you want to go. So one thing to keep in mind is assisted living or personal care homes do not accept Medicaid benefits. They are all private pay in Pennsylvania. So even if you had a trust, your trust protectors may need to use those trust assets if you don't have money, if you would want to live in an assisted living personal care home. Some nursing homes that are in Pennsylvania do not accept Medicaid benefits. So depending on where you live, you might find that there are some facilities that are private pay only. Now, if you are in the Lycoming County area, all of the nursing homes in Lycoming County are licensed to take Medicaid, so that wouldn't be a problem. But some nursing homes do prefer private pay, and they may have a requirement that you private pay for 6 months or 12 months. And what's nice is if you have a trust, there are those options, whereas if you had no money because you've spent it all, you really are limited to where you can live. So Brittany talked about Medicaid and the look-back period. So really the purpose of the Asset Protection Trust is to qualify for Medicaid, so you're not spending over $10,000 a month on your care. But there is a gifting look-back, and so that look-back period is 5 years from the date of application. So, for example, if you went into a nursing home today, August of 2020, they would want to look at all of your financial statements from August of 2015 to August 2020. So people are often saying, well, how will they know if I made gifts? They comb through 5 years worth of bank statements. And if you forget to tell them about any certain bank account or investment, they actually share information with the IRS. So any income or anything reported to the IRS would actually come to the Medicaid office, and then they would come back and question that. So if you have gifted assets and you need care within 5 years, what will happen is Medicaid will deny your application. Now, they won't say come back 5 years later. They actually impose a penalty period. So they have a formula to figure this out, but for every $10,732.83 that you give away, there's a 1 month period that you would become ineligible for Medicaid. So if it were less than that, they actually do have a daily penalty divisor. But this is just a very important thing to keep in mind because they have very few ways to forgive this. So we do encourage our clients to make sure that if they do not have substantial assets to pay for care, that they really do limit their gifting to $500 per calendar month. And that's not per person, that's a total per month. So what that penalty period means is, let's say that you had a property that was worth $200,000 and you gifted it to the trust. Medicaid, if you needed care within 5 years, is going to impose a penalty of 18.6 months after they divide the value of the gift by that penalty divisor. So how this might work if you did planning and you do go into a nursing home is, so let's say you transferred your $200,000 property in November of 2014 and then go into a nursing home in November of 2018. So you haven't quite made it through the 5-year look back. There's still another year left, 12 months. So in that situation, rather than apply for Medicaid and get a penalty started, which would be greater than 12 months, as you can see there, we would just say private pay for 12 months, and then the penalty will be over. So what happens if you don't have any money? So in order to private pay for 12 months, your trustee may need to sell the property, and your trust protectors may need to take some money out of the property. Another option would be to take a loan out of the property, depending on the amount of loan that could be made. Or if you had any children that could pay for care, they could file a lien against the trust and get paid later on when that property sells. So there's a number of options that we would look at. But you might say, well, was it really worth it to put the property in the trust? I still needed money to pay for care. But you'll see in this example, if you hadn't done anything, you could have lost the full value of the property, $200,000. But in this example, you're actually still protecting about $80,000 that would have been subject to care. So if the property's worth $200,000 and you need about $120,000 to pay for care for 12 months, there still would be a net profit of $80,000 protected. So we have a couple more scenarios and options of, how could a trust help me? So we've got Harry Smith has a home. It's valued at $200,000, and he has $400,000 in assets. So he did not put everything in a trust. He put his house in a trust and $300,000. And then he needs a nursing home care in 2018. So he's made it through the 5-year look back. And between 2012 and 2018, the money he kept outside of the trust, he used to pay for personal expenses, maybe some caregivers or assisted living. So that money is all gone. But the property and the money in the trust, which totaled $500,000, are 100% protected from nursing home care because he has made it through the 5-year look back. And very important, as Brittany said, if that property is still there after he passes away, the state of Pennsylvania cannot file a lien against the property for the cost of care. So let's say he's in a nursing home for 8 years and Medicaid pays $800,000 for his care. They cannot come back after those trust assets. They're all protected for his beneficiaries. So what happens if I don't set up a trust and now I need long-term care? So we've got, we can still do something that in a crisis situation where you've not done asset protection, but we can't do as much. So we wanted to give you an example of how that would work. So we've got John Smith, and he has a home worth $200,000, and he has $400,000 in assets. He did no planning to protect these assets. So now he's got $600,000 available for his care. So in order to qualify for Medicaid, you have to have less than either $2,400 or $8,000 in assets, all depending on your monthly income. So in this situation, he could lose basically everything without planning. Now, again, if there is a situation where you need nursing home care today, there are still some options to protect some of that money. So, so do call us and we can help you through that. So when you should consider a trust is a good thing to consider when you have your property paid off, or you might have just a small mortgage or home equity line of credit. When your children are grown and out of the house and you no longer have to worry about paying for college or large expenses on their behalf or your own behalf. And then if you have assets that are starting to accumulate. So as Brittany said, not everybody puts assets in a trust. Most of our clients are just putting their primary residence in a trust, and that's okay. But if you do have accumulated assets that you don't plan on using for anything, putting them in a trust is definitely a way to shield those. Another consideration is if you have a family history of medical conditions that could require long-term care. So family history of dementia or Alzheimer's, or let's say Parkinson's, or any sort of rheumatoid arthritis or a chronic condition where you think, gosh, I really might need care in the future, you really would want to start this planning as soon as possible. And then if you just have a desire to really want to make sure that the nursing home or the state of Pennsylvania doesn't receive everything you worked hard for, that's when you would want to consider a trust. All right, so I already referred to this, but even if you have not done planning, there are some ways for us to assist in a crisis situation. People are often very surprised to hear that. If you are married, we can protect almost everything. If you are widowed or single, we can protect about half of what you have without the pre-planning in place. Okay. And what to expect at Steinbacher, Goodall, and Yurchak? Well, we have a team of attorneys, certified Medicaid planners, long-term care planners, and support staff who are knowledgeable about the legal planning, asset protection, benefits planning, and community resources. So we really work as a team here, which is really great because you're really getting a lot of different expertise when you're working with our staff. We also do individualized planning. So as Brittany said, the first thing we're going to ask you is, what are your goals? What's your family situation like? What do you want to accomplish? And then that planning that we do is really formed around those goals to make sure that they're accomplished. We provide good quality documents, and Brittany does prepare all of the legal documents for her clients. So rather than have a paralegal prepare them, Brittany is taking the time to actually type them up, read them over, make sure that she's applying the law in every aspect. So that's a huge benefit as compared to some law firms. And then really the one thing we hear from clients when they get done with this, we send out client satisfaction surveys to our clients, and we are always hearing them say, we have peace of mind. We know that we did everything that we can to control this situation and make sure that the outcome is going to match our goals. So what we're doing right now, so Matt had mentioned that some staff are in the office, so things are actually changing every single day. But what we're still trying to do is have our client appointments over the phone or through a Zoom technology like we're doing right here. And we are still doing some face-to-face. So if somebody has hearing impairment or it just makes it easier for them to come in face-to-face, we are doing that, but we are very much limiting those. But we do want this to be as personable as possible. So things seem to be working out pretty well with the Zoom meetings and doing things over the phone. But what we would do is after somebody has their meeting and they retain our office, we would have a follow-up meeting with them to review their documents over the Zoom, and then making sure that everything is accurate the way they want. And then we would have them come in the office for a brief signing appointment. And, I'm sure that you guys know we're following all these rules, but we are sanitizing the doors and the tables and the chairs in between every appointment to try to make it as safe as possible for our clients as well as our staff. Okay, and keep in mind that we do offer a free consultation, and that is a very generous thing that I think that our law firm does offer. So you can come in and talk with us about your specific situation and your goals, and there's not going to be a fee for that. And then what we would do is quote you a fee based on whatever you would want to do. So we do a la carte work, or we do flat fee planning. The flat fee planning would be most financially beneficial to you if you're getting a large number of documents. So we would go over that with you. And then as a thank you for attending the seminar, we are offering a 10% seminar discount coupon. And so whatever your fees are, there would be a 10% discount. So that's also a pretty big deal. And Kyle will make sure that he sends that out to you after today. If you have any follow-up questions for us, we are going to give you a few minutes to ask those questions here today, but you can always call our office, and we have our toll-free number listed here. It is 1-800-351-8334. You can also send inquiry questions at our email at info@paeldercouncil.com. And our website is also listed there, www.paeldercouncil.com.